I'm Sherren, claim attorney with Minnesota Lawyers Mutual. When making the decision to go to law school, many young lawyers have high hopes of seeking justice and helping to solve problems for people who have been wronged, whatever the personal cost. But then, reality sinks in. It takes money to run a law practice, and if you are not getting paid for your work, something's got to give. This talk is about the perils of fee disputes with your clients, how to avoid them, and what to consider before bringing suit against your former clients to recover fees owed to you. While a lawyer has the right to bring suit against a former client to collect unpaid fees, this may not be the best approach to take. Industry data reflects that as many as 20% of malpractice claims filed against lawyers are responses to suits for fees. Many of these claims are completely lacking in merit, but it can take quite a bit of time and money, not to mention personal and professional stress, to prove that. Many lawyers who have sued their former clients to recover fees have found the personal and professional costs to defend the malpractice claim far outweighed the fees they were trying to recover in the first place. Generally speaking, Minnesota Lawyers Mutual advises against suing former clients for fees. MLM does not provide counsel to pursue a fee claim, but would defend a malpractice counterclaim, assuming other factors do not exclude the counterclaim from coverage. Even though MLM would bear the cost of defending a malpractice claim, lawyers should think carefully before suing for fees, because even a malpractice claim that lacks merit can wreak havoc on a sued lawyer, both professionally and personally. Malpractice insurers nationwide have seen that malpractice allegations materialize when a client feels attacked by his former lawyer in the form of a lawsuit to recover fees, even if the client agrees that the fees are owed. Countersuing for malpractice is a fairly common strategy to reduce the amount of fees actually paid to an attorney, or to get out of paying for the legal work performed at all. So, how can lawyers protect themselves and ensure that they are paid for the work they have done? The best approach is to avoid potential fee disputes using the following guidelines. At the onset of representation, be sure your client signs a fee agreement that clearly sets forth the scope of representation and a proposed billing method. The agreement need not be the same for each client, but whatever the terms, it should be understood and agreed to by each client in writing. Next, collect a significant retainer up front. Use interim billings, typically monthly, to avoid one large bill and itemize the services provided. It's important to be consistent with your billing procedure and payment expectations, but to also work with clients to formulate an alternate payment plan when necessary. It can be awkward, but it is very important to ask some hard questions when forming an attorney-client relationship. Some of the questions to discuss are: what is your ideal outcome? And knowing there are no guarantees, what can you accept as an outcome if your ideal outcome does not happen? What amount do you expect to pay in legal fees? How will you pay my legal fees? Can you pay me a significant retainer today? Can you pay with cash today? With a check? With a credit card? How much can you afford to pay per month in legal fees? Do you really have the funds to afford my legal fees? Before pursuing a suit for fees, be sure to consider the following. First, is the amount at issue critical to the firm and worth the risk of a malpractice claim? Next, did the client receive a satisfactory result? Are you sure? Third, has an objective third party reviewed the file and found it up to standards? Fourth, has the firm considered fee dispute resolution? Fifth, would a favorable judgment be collectible? And sixth, would the firm accept a lesser amount as a compromise? A critical administrative step in managing any successful business, including a law practice, is to work the receivables and keep them current. The older the receivable, the less likely it will be to be collected. Lack of action in this area only compounds the problem, as more small bills grow into one large amount due. Often, the total amount due grows until paying it off becomes a very significant burden. This problem could be avoided by quicker action when amounts due are smaller and more affordable. Another helpful measure is to seek feedback from the prospective client before reaching a formal fee agreement at the beginning of the representation. The initial client intake form is probably the best opportunity for client feedback during the fee agreement stage. Clients are asked to describe what they hope to accomplish. This allows the attorney to better understand the reasonableness of the client's expectations. The clients are also asked what they expect to pay for the legal services provided, which allows the attorney to determine upfront whether a balance exists between the desired outcome and the likely legal bill. By successfully managing and collecting fees before they build up, lawyers will increase the likelihood of avoiding the necessity of suing to recover fees, and avoid altogether the related potential malpractice lawsuit.